When a person is stopped for driving under the influence of alcohol, a case essentially begins. And while somebody might think that because they gave a particular breath test or they believe that they were above a certain level, that they automatically don't have a defense available to them, this is extremely untrue. When I look at a DUI case, I usually look at that case like I'm looking at a ladder, and I'm trying to see all of the steps that took place during the course of the case and how it's going to be prosecuted by the state's attorney's office. When a state's attorney is attempting to prosecute a DUI case, they need to look at that ladder and look at each step that the officer performed during the course of the case to determine what information is admissible. DUI cases typically start with a vehicle being stopped for one reason or another. This is perhaps the most important part of the entire DUI investigation. If an officer is unable to later explain why he stopped a person's vehicle, any information that came after that vehicle was stopped is usually considered inadmissible and the state's case collapses. Let's assume for a moment that an officer is able to prove that the stop was legitimate. The next step in a DUI case is for the officer to approach a person and determine whether or not the basis for the stop was in fact legitimate. After interviewing the individual who is driving, the officer may smell an odor of alcohol, may hear slurred speech, may see bloodshot or watery eyes, and determine that it's appropriate to ask a person out of a vehicle. If the officer doesn't see these things, he must let the person go. Again, let's assume that the officer did see that a person had slurred speech or some indication that that driver was in fact consuming alcohol on that particular occasion. Usually, the officer then asks a person to step out of the vehicle to begin doing field sobriety tests. Now, everything that the officer did up to this point is what I would consider based on his subjective belief. An officer certainly can't prove that you were driving under the influence of alcohol just based on the reason that he stopped you, and perhaps wouldn't even be able to prove it based on just an odor of alcohol or slurred speech. He needs to come up with some objective standard which will actually constitute probable cause to place you under arrest. That objective standard is usually done by administering field sobriety tests. Field sobriety tests are standardized, which means that they are mandated by the National Highway Traffic Safety Administration to follow particular instructions. The officer has to give an individual those instructions in exact accordance with the standards that are dictated by the National Highway Traffic Safety Administration. Any faltering of those standards could yield those field sobriety tests inadmissible. Again, let's assume that the officer is giving field sobriety tests properly, and the officer has determined that there was probable cause to place a person under arrest. Once that person is at the station and is offered a chemical breath test, the officer has to go over an advice of rights form with that individual so the person knows that they are not under an obligation in the state of Maryland to submit to a chemical breath test. This differs from many other states in the United States of America where not taking a chemical breath test can land you in jail. In Maryland, there are no criminal penalties for refusing a chemical breath test, but there may be some collateral consequences at the Motor Vehicle Administration for your Maryland driver's license. If a person chooses to take that chemical breath test, it will be admissible in court only if all of the original steps of that ladder, the stop, the second stop, the standardized field sobriety tests, and appropriate probable cause to arrest have been established by the police officer and the prosecuting attorney in court. Driving under the influence of alcohol can carry significant penalties, up to 12 months in jail, up to 12 points on your driving record, and a $1,000 fine. Additionally, the companion charge of driving while impaired by alcohol can carry up to 60 days in jail, a $500 fine, and 8 points on your driving record. It's important to work with an experienced Maryland DUI attorney who is aware of how to mitigate some of these penalties. An attorney can be effective in assisting a person avoid jail time altogether, points on their driving record, and significantly reducing the fines associated with a case.